Ontario. Chief Bird, would you do the blessing?
Thoughts now? Most gracious Heavenly Father, thank you for this beautiful day, and just thank you for the rain throughout our area. And be with the leaders of the tribe and be with the council members as we go through today's meetings and try to take care of our people. Guide and lead us and forgive us where we fall short. In Jesus' name we pray. Amen.
Shall we call the roll?
Chuck Huskin Jr.
Here.
Bill England.
Here.
Joe Bird.
On you.
Jody Fishinghawk. Janelle Fulbright. Don Garvin. Frankie Hargis.
Present.
Hannah Boyd Jordan. Lee Keener. Dick Lay.
Here.
David Snell. David Thornton. David Walkingstick. Kara Callan Watts. We need one more for a quorum.
All right. We'll suspend activities till we get another council.
So who's out there then?
I think Councilor Callan Watts is out there if we can grab her.
Timer's out there.
Yeah, Tyner. While we're waiting, it's not the conduct of business, but Shelley, am I correct that the committee got to section 5B of the contractor law?
On page 7.
Very good.
Yes.
So we'll direct our attention there.
What page are you reading?
We are at page 7. More specifically, I believe at part B.
I'm sorry.
That's okay. And councilors, we are at section 5B, found at page 7 of the Contractor Acts. I think we're still in discussion from last time. We have, our time is short today. We have a subcommittee at noon, but I'm going to be ambitious and suggest that we might get through the rest of this act if we can focus our questions on what we have questions on. If we're fine with the section even as amended, I would suggest a motion to approve an entire section would be appropriate. So we're now at section 5B. Mr. Overacker, you'd be available for any questions on this section. Councilors, with the remainder of section 8, I keep saying section 5, looks like it's section 8B, found at page 7. My apologies. Councilor, do we have any questions on the rest of it? Yes, Councilor Callan Watts.
Mr. Chairman, just to clarify, so the ones with the stars are the ones that we have already passed in the prior committee, is that correct? Is that how they're?
Mr. Overacker?
That is correct. And if you, we need to, if you
So
don't.
we need section 4I for emergency is in red, and we still need to address that.
Correct.
That's our first.
Correct,
Okay.
because we need to go back to page 2.
Okay. We need to go back to page 2. All right, very good.
At our last meeting, the council actually wanted us to look at defining something that was an emergency situation. So we're going to kind of, the emergency means a condition that places an extreme emotional or financial burden on a Cherokee citizen. We would like to see if the council would add or to the Cherokee Nation or its entities. The Cherokee citizen was based on the fact that if we had an elderly couple that their air conditioner went out in the middle of July on a Friday afternoon at 4 o'clock, we wanted to actually be able to bypass some of the processes so that we could actually get their air conditioning back on for the elderly couple themselves.
I have a question, Councilwoman, but you may have the same question.
Go ahead.
Well, my question is, can you think of a circumstance in which there's an emergency that doesn't pose an emergency for our citizens, which I think is what we normally think of when we think about this significant loophole, if you will, in the law. Can you think of a circumstance when we'd have to and it didn't affect a citizen? Because I think that's what the language you're talking about would do.
A situation that we didn't have to.
Right, you said or to the Cherokee Nation or its entities. So in other words, there might be an emergency that doesn't affect our citizens, but it just is some burden on the Cherokee Nation or its entities, and I'm struggling to wonder what that circumstance would be.
An example would be, just a quick example would be, for instance, if we had a generator go out at one of our casinos, and we need to replace that generator within as soon as we could to actually keep the casino running. That would be a quick example. Or an air conditioning unit or an air quality control unit that actually went out inside the casino and wasn't taking care of the smoke or something else and things like that might affect the business itself financially.
It sounds like it would affect our citizens too. The Councilwoman, did you have a question?
Thank you. So I guess there's many more questions that I have concerning this, because what it'll impact, the way we're strengthening the tarot law, we're allowing those citizens more rights as tarot vendors, and potentially non-tribal citizens that are other Cherokee, or other tribal citizens in our courts to come in and challenge that if we do not use a tarot certified vendor, that they could challenge us under the tarot law. So if we don't use a tarot vendor, so even in the circumstances of like the unit to keep the casino running, if it was a generator or such, to me, if we've done our emergency management plans properly, we would already know who our vendors are, and those would be probably bid, even if we don't ever use them every year, what would your price be? And we would already have that in place. And because we know with Snowmageddon and these other things that have happened, that we could always be at the need of it. I mean, I know it's not, we could plan for that emergency even in that circumstances. So where's that line if we go into court? You know, where's the burden? Who has the burden? Would we go to a courts and appeals? Who will determine that whether it's an emergency or not? How will it be documented? So in that definition, even though we're only at definitions right now, to me, it's still fuzzy, and I think that, Mr. Chairman, I think that's what you're alluding to too, is where's the line and how's that determined?
And my concern is that the definition as it was written in the book probably is workable, but if we start adding CN and its entities, it starts to open up that loophole. It seems to me that if an HVAC system goes down at the casino and you have to fix it right away, our citizens are surely in some jeopardy in terms of their health and safety, because our citizens work in the casino and they are patrons of the casino. So it fits into the definition already. I would be hesitant to add that language, but it's the will of the body. I think ultimately whatever language you come up with, it's going to be heyday for the attorneys who are going to duke it out. So at some point you can't write these things beyond dispute. Councilwoman.
Why does sole sourcing and the justification for sole sourcing not allow for this without creating another definition?
Well, sole source can be different things. Sole source can be a single source. It can be actually a reorder source from an existing contract that we have. A sole source isn't just in general, just for a sole source. They're picking one vendor, but there are several different reasons why someone may pick the vendor. It may be a single source that we've actually, an example, we have a machine even at the hospital from Corning or something, that Corning restricts us to actually use this vendor to keep their systems certified or equipment certified, things like that. That would be a single source. A single reorder, I'm saying this wrong, and the purchasing department probably can absolutely help me. If we do, we have to reorder from certain products from certain people to keep what we're doing in our current contracts. So we can't bid those out to tarot vendors. We may lose the warranty. We may lose existing things that the actual equipment that we purchased first holds us to. So there's different scenarios for that as well. I understand. We could actually, on the emergency, we could actually add to this where we could get some type of definition where tarot vendors need to be actually called before all other vendors are called in an emergency situation. That may force us to actually have a better plan of where we're going for the Cherokee Nation and the entity side as well. So we know if something goes out, we have these 5 tarot vendors that are qualified. Well, let's call them first, see if they can actually do this for us. So we can actually add part of that if you'd like.
I'm not an attorney at the table, so Mr. Chairman, I'm looking at you because of your personal background and expertise. I just think that's a more workable solution. You know, that we require that it's upfront and clear rather than some ambiguous definition of what emergency might mean to somebody on one side of the table versus the other.
Councilwoman, could we just add after all reasonable efforts to solicit work from a tarot vendor have been exhausted to the end of that original definition?
That would be good.
I'm good with that. I don't know how the body feels, but.
I'd entertain a motion to approve I with the addition of strike the period at the end of the sentence and put after all reasonable efforts to have been exhausted to contact a Taro contractor.
So moved.
Here. All in favor?
Aye.
All opposed, same sign. Anything else on that?
I will make a comment.
Mr. Keener is next.
Okay.
Chief, Mr. Keener?
Thank you, Mr. Chair. While we're on the emergency, if you could explain blanket POs, or would that be essentially an open PO for vendors? So if there is an emergency, they could be contacted, or is that not what that's designed for? Or I'm asking you to explain if I get it.
I'm gonna ask Jason and Rebecca on that. The blanket POs aren't set up for emergency reasons, though. They have actually changed how they do blanket POs on the entity side, and Rebecca can explain on the government side how we do that, because we changed how we actually do that.
Okay.
Please come forward if you would.
Usually has no problem carrying. We have agreements that we have set up with vendors at the first of every year. And these are, you can call them an indefinite delivery contract, memorandum of agreement, but basically they're set up for convenience for the programs in case they have an emergency. And what that entails is, pretty much should we do business with you during this fiscal year, here are the terms and conditions that are going to prevail on that. And then what happens is when the department has an emergency, they have to enter a requisition into Lawson, and we assign a PO so that that vendor can come out and do the work. So those are set up for emergencies.
So a printing company they could conceivably have an emergency, like print T-shirts?
That's not a usual thing that I'm familiar with. Normally, these are set up with contractors, electricians, people like that who are basically work on our facilities and buildings.
Well, I don't know if I can't speak for the body, but I'd like to see a list of where those blanket POs are, because that's my understanding is a printing company has an open blanket PO. So
we have a lot, so it's conceivable they could. I'm not. Now, a blanket PO is a little different than these memorandum of agreement for emergencies. We do have blanket POs, and those are issued at the request of the programs. If they are not given to a Taro vendor, we require a sole source from that executive director to open that blanket PO.
Well, that's what we're
If it's
discussing
with
right
a
now, is
Taro,
emergencies.
right, and so there is a difference between them, the blankets and the memorandums of agreement. The blankets are not normally emergencies. They're just set up at the request of the programs for repetitive purchases.
So I think for letter I, that's acceptable, but I guess we'll get into that later on.
Okay. Okay.
Thank you, Mr. Chair.
Thank you, Councilor. Councilman Burke?
Yes. Mr. John,
Yes, sir.
what was the reason for this language now? In the past few years, were you not operating efficiently and taking care of the needs of the people without adding this language? Why now?
I think the emergency was taken from the last time we were here. It's been left up to the departments or the entities to define emergencies. So if they consider it an emergency, it was an emergency. I think that's why we actually defined it from this body from last month, to tie them in and everything else, to make sure that we have a correct definition of what an emergency is going to consist of and how it's going to be proceeded.
Okay. It's going to be at the director's discretion now, right? Using this definition and.
Yeah, I believe it still will be. With this, it has to be somewhere, but as long as even if the director says, okay, it is an emergency, as long as we're going to, we have 5 Taro vendors that we have to call first.
Sure.
I think that's what we want anyways, to use our Taro vendors. So I think that's the way it'll work. It'll work well that way.
Okay. Thank you, Mr. Chair. Thank you, John.
Thank you, Councilman. I think that takes us to page 7. Is that correct, Mr. Obracker?
Correct.
And First of all, do any council members, having had a chance to review this section, have any questions about the language? Councilwoman Countwise.
Thank you, Mr. Chairman. So, just a comment on, I have several questions, but I have some comments as well. So on the first part, I think that we do need to consider on that B, on page 7 towards the bottom, that is that debarment list and those things is really why we need probably the Tarot Commission or whatever that board or whatever it's called to possibly be under the Administrative Procedures Act, because a lot of things that we're doing lends itself to the public input and the disclosures and the transparencies that the APA talks about. So I just want to leave that thought for the folks on the committee to consider. But on the last sentence of B, the procurement offices shall forward the names of these certified Indian-owned businesses determined to have poor performances to both the Tarot and to the One-Stop Business Center for technical assistance and improvement. I'm concerned that we're not also holding all our vendors to the same standards that we are the Tarot vendors. So we're almost putting additional burdens on the Tarot vendors if we don't also put all vendors through these same processes. Now, I think the technical assistance only goes to the Tarot vendors that sentence speaks to. However, the debarment list should apply to all vendors. And so I'm concerned about how we actually logistically implement that, because we can't just say, come pay us $45, let's get into your tax records, let's verify you're Indian, and because you're Indian doing business with your tribe, we're going to do these additional requirements.
Would the
But not to everybody.
Councilwoman, would you yield for the question?
Please.
I agree with you 100%, and I wonder if we shouldn't follow up with some Contractors Act that says, and we can get specific, but certainly the philosophy behind it will be that all people who contract with Cherokee Nation shall be held to at least the standards that our Tarot vendors are. And I agree that whether they're Tarot or not, if they're poor performers or lawbreakers, we shouldn't do business with them, for example. So I agree, but I wondered if we could take care of this in a separate act, or do you have some language that you would like to put in here that would embrace all other contractors? Because I had in mind maybe a separate act for contractors, but I'm open to.
Well, to clarify and make sure that the laws are easily read and understood by anyone that picks them up, I'm okay with separating them, but I'm not okay without it all happening at once, because right now we would be putting undue burden on just our Tarot vendors, and I want to give them assurances that everyone would have to comply.
Well, and I think either this subcommittee or the Rules Committee, we could get some legislation that could address that, and we could pass that, alongside this, consider it. So, Mr. Overacker, did you have?
Well, the intention of this section was actually to separate the non-Tarot vendors and the Tarot vendors, to, if a non-Tarot vendor actually would go to the debarment list much faster than a Tarot vendor. We were looking at giving a second and possibly a third chance to a Tarot vendor who failed to perform to the standards of the contract or poor performance, so we could actually get them to the One-Stop Business Center, so we could give them training so it wouldn't happen again to them in the future. It's not for us to, it's actually to slow the debarment process down for our Tarot vendors, so we can actually coach them and teach them how to better their business and to perform better, not just for the Cherokee Nation, but for the outside businesses as well, to make them more successful.
But is it a fair statement, Mr. Overacker, that if you're not a Tarot vendor, there is not a statute hanging over your head that says you will be debarred? Rather, it's been the practice of Tarot to debar non-Tarot contractors, but there's not a statutory authority that says you can do that. Am I incorrect about that?
Correct, and Nation and I we have talked about that several times, that we need to look at something in to do that.
And I think that's what the councilwoman's talking about, is to make sure that there is teeth to a law, that there is a law that says you can debar a non-Tarot, and I think we should do it in a separate act, frankly.
It would depend, and I'd have to look at how you define contractors, because how they're reading and applying it was you could make the department list much faster if you did not meet the definition of a certified Indian-owned business. But if you were a certified Indian-owned business, before they would put you, and this is how it's been interpreted, before they would put you on the list, you had the an opportunity to fix whatever mistakes you were making, and then the next opportunity you're going to make the list. And that's how it's being read based on the definitions. If we need to clear that up, we can do alternate language.
Okay. But if we wanted to make sure we could hold non-Taro contractors accountable and that they would be on a debarment list, do you think we need a separate statute to give Taro that authority, to give someone that authority?
Can I ask a question? Do you regulate and issue fines to people that are non-Taro?
Yes.
Okay.
Yes,
I
we do.
think that they have the ability to put them on the list, and on this one, the nation and its entities have a list. I think this list is separate than a Taro list. I think the Taro has an independent enforcement, and this one I have read in the past to show that the procurement offices of the nation keep a separate list to say, okay, you've underperformed, you're on the list. By the way, Taro, here's a couple that aren't performing. You might want to help them. But I have seen this one, interpreted this one to be the nation and the entities keep an independent list through their procurement offices. And if you make that list, you can conceivably, with the rules, get off that list. But this would be a list that's maintained by the actual Cherokee Nation or the entity, separate from Taro.
So, Mr. Overriker, if you had two contractors that were similarly bad actors, one of them was Taro, one of them was non-Taro. Under the language as it's written now, you could put the non-Taro on a debarment list.
Correct.
The Taro vendor would be told, we're going to help you correct this defect.
Yes.
And if you do that, you can stay off the debarment list.
Correct.
Which is not something we would afford the non-Taro.
That is correct.
Okay. Further down, section B1 deals with these contractors certifying that they're not lawbreakers. What I want to make sure is that we make all companies that do business with Cherokee Nation certify that they're not lawbreakers. And so I wonder if we need to tweak this language or come up with a separate statute. That's a priority for me, is to make sure that lawbreakers are not benefiting from the Cherokee Nation. So if we need to tweak that other section, we might look at that either in a separate statute or in this language. But if you have any thoughts on that, you can share them now. We can.
No, yeah, I actually get with Nason more on this, and we can actually try to, if we can keep the language like this, and we can come up with an alternative section to kind of change it, to kind of tweak it a little different way, and we'll send both of them to you and after a few days after this meeting, and you guys can actually look at both sides to see how you would like to change that or see how that's done. Would that work for you?
We've got to do something, so
Yeah,
thank you. May I continue?
certainly.
Okay, so on page 7, section B1A, I'm concerned because it looks like we're putting a lot of additional burdens on our small businesses, and our Taro business particularly, and we're not holding the non-Taro businesses that are vendors with us as well compliant with these same things. And we're not even lending itself to our own minimum wage act. We're referring to the Oklahoma minimum wage act rather than Cherokee Nation minimum wage act. I mean, right now as it is, I can't support this, but I want to hear why we need to, so I can.
If the counselor would yield, I could speak.
Please.
First off, you are correct that this places a burden on Taro contractors that I think is not placed on non-Taros, but my feeling is we need to, anybody who does business with Cherokee Nation needs to comply with this, and if we need to change the language to make that happen, I'm pleased to do that. The list of labor and employment laws should include the Cherokee Nation minimum wage law, and it was just not omitted consciously. But I do think I mean, our Taro office is going to have a hard time investigating every contractor to see if they're under investigation or if they violated a federal law. They can do some research, but if a contractor lies about it by telling Taro, hey, we didn't violate the law, and then they're later found to be, there can be consequences for that. So I think it's important that they have to certify when they do business with Cherokee Nation that they're not a lawbreaker. And we can expand this list of laws more. We can contract it because it says any other such laws deemed appropriate by Taro. So that was my goal in this section, Counselor, and I'm happy to work with you language. And I don't think it creates much of a burden on an employer to say, we're not lawbreakers. So, as long as we do it across the board, Terra and non-Terra. Council.
So do we have an estimated economic impact to our small businesses and such? I think, I'm not familiar with all these laws, but some of them are triggered by the size of the business, I believe, like the number of employees you have. I mean, I don't know all the nuances. So I assume it'll take a couple of weeks of their time and labor and resources, maybe some legal fees, human resources folks they don't have. I'm curious what that is.
I would suggest that it is not difficult for a small business to say that we don't violate the wage and hour law because we pay our employees. If an employer knows they've been prosecuted by the U.S. Department of Labor, they know it. It doesn't take legal research to do it. They know it because they've been prosecuted. And if they've been prosecuted, they need to tell us they have. And if they lie about it, they need to not do business with us. So I would suggest it will not be that expensive to comply with these provisions. If you're a business, you know if you're in violation. You know if you're under investigation.
I'm talking about the civil, may I?
Sure.
So I think that's a different part, and I still have questions on that. What I'm talking about is A, where it's the compliance with those federal laws, such as Civil Rights Act, Fair Labor Relations, Labor Standard, Americans with Disabilities Act, or a bunch of people gonna have to go install handicap ramps they never had, hire folks that they maybe never, I mean,
If
Equal
you're,
Pay Act.
all I'm suggesting is they ought to obey the law.
Yeah.
And if a small business comes to us and say it's too burdensome to comply with federal law, then I really don't want to do business with them, which is precisely why we need to ask these questions. I don't think it's going to cause them to comply with a law that they otherwise would not have to comply with. What it's saying is that they need to certify on an annual basis that they haven't been prosecuted by the U.S. Department of Labor, for example, that they haven't been lost a lawsuit because they violated the Civil Rights Act. They know if they have, and they should tell us if they have. And that ought to be a factor in whether we do business with them.
I take that as B, and I'm still looking at A, that everybody has good intentions. What are they gonna have to do to comply with all these federal acts that we're suddenly throwing at them, and why are we only doing it to Taro and not all our vendors?
Well, Councilwoman, I would repeat that my goal is to apply it to all council members. And we're not asking them to start complying with federal law. We expect that they should comply with federal law. And what we're telling them is that if you want to do business with Cherokee Nation, you need to certify that you are in compliance. And if you lie to us, you're not going to do business with us. That's all that's saying. It's not adding any additional legal burden other than to tell us the truth. And if telling us the truth about compliance with federal law is a burden, then I don't want to do business with those folks. Ms. Parker Harold, did you have a question?
Deputy Speaker, Mr. Chairman, perhaps part of the procedure could be that they sign a sworn statement that they're complying, or that we add a provision, something that says that they're to supply to Taro or the tribe that they've researched it and such doesn't apply to them, so that that's on record and protects them too. Because there are, like Councilwoman Watts said, there are certain things that won't apply to smaller businesses and things like that. So maybe there should be a way that they could certify they've researched it and they can submit something.
And I would think that for most small businesses that want to comply with federal law, they've already researched whether they're obliged to follow federal
So
law.
they would know and be able to tell you.
And if they're not in tune with what their obligations are, then again, I question whether we should do business with them. Councilwoman Conlon.
I have two questions, well, actually more than that. All right, first of all, why are we not referring to our own minimum wage law and we refer to Oklahoma law?
I can repeat my answer to your question, which is that it was not omitted consciously and that it can be expanded to your heart's desire.
And then, so I would say that we need to add the Cherokee Nation minimum wage law, and I'll make that in the form of a motion.
Is your motion to approve Section B with that?
No, it's to add Cherokee Nation minimum wage law
Okay.
compliance.
Do we have a second?
Second.
Okay, all those in favor say aye.
Aye.
All opposed,
I
same sign.
oppose.
You oppose, okay.
You're taking the competitive advantage away for the Taro vendor when you tell them we're gonna, everybody in their business is $7 and something to $9 and something.
Madam Speaker, could I respond to that? If they're not already required to comply with, say, the Americans with Disabilities Act because of their size, we wouldn't tell them they have to comply. If they're not already obligated to comply with the Cherokee Nation Minimum Wage Act because they're not under that jurisdiction, then I don't think that is telling them they have to comply with that
And
act.
why put it in there?
If they are obliged to comply with it, then that's a good point. That's a good point.
So on the Cherokee Nation minimum wage, the only reason I see for asking them on these federal laws to suddenly comply on our jobs, because if they're doing private work, they will not necessarily have to comply. There's not a sense of the small startup businesses. So if we're really about making sure that people on our jobs are being paid fair labor wages and those kind of things, I would think we would want to do the Cherokee Nation minimum wage, even if it costs us additional money. That's the whole essence of government work. That's why I assume all these federal laws are suddenly being thrown at folks for compliance. I mean, help me understand. You do this every day, so I'm trying to understand better why we're doing this.
Let me reiterate that compliance with federal laws are not suddenly being thrown on these contractors. They're already obliged to obey these laws. This law doesn't change that. Now, if they fall below the employment threshold, then they're not obliged to comply. What this says is that if you are a lawbreaker, we want to know about it. That's all this says. It doesn't say, yesterday you didn't have to comply with the federal minimum wage law, but now you do. It's just saying if you do have to comply with it, then are you obeying the law? Or have you been prosecuted for it? And if you have, tell us about it. And if you lie to us, there'll be a consequence. That's very simply what this language does. Does that answer your question,
One
Councilman?
more question.
Yes.
So we've now put, if it passes as it's already being shaped up, will the Cherokee Nation then comply with all these?
If they're obliged to. If they're, for example, there's court cases that say they're not obliged to comply with the National Labor Relations Act. And if they're not obliged under law to comply with it, then all they have to say is, we're exempt from that law. And I see Mr. Obracker shaking his head in agreement. And Councilwoman Cowan wants to have any other questions?
Do we need to reconsider the Cherokee Nation minimum wage addition?
As I see it, if these laws apply to you, then you should be in compliance with them. If they don't apply to you, then it doesn't matter whether you're in compliance with them. So it's the will of the body.
So to make sure I understand the way, if this passes with the addition of Cherokee Nation minimum wage, if they do a job for Cherokee Nation, whether it's on trust property or not, they, for that job, would have to pay that minimum wage.
I disagree with that, and I would yield to Mr. Morton. If they have a pre-existing obligation to comply with the Cherokee Nation Minimum Wage Act, then are they following it? If they are not under that act obliged to follow it, then it's irrelevant because they're not already obliged to comply with it. Mr. Morton, do you have any different take on that?
I agree. I would like to suggest language, since Cherokee Nation and the entities would be involved in this, language saying nothing herein constitutes a waiver of sovereign immunity, just to make sure there's no question later on that when these acts do not apply to us, there's no question that we did not make them apply to us.
That'd be a good point. Constitutes a waiver of sovereign immunity or an obligation to comply with a law that the entity does not otherwise have an obligation to comply with, just to be redundant and to satisfy any concerns.
Yes.
Thank you. Councilwoman Cowan.
Mr. Chairman, I thought we already included that change that the Cherokee Nation would have to comply with Terra law.
I'm talking about the others in that list that may
So
not
only to
necessarily.
this section.
Yes, only to this section, because
Okay.
Davis-Bacon, I don't want us to accidentally on this list if we're not.
Right. Thank you.
Yeah, and I think that makes sense.
So I'll make a motion to add that?
Certainly. And do we have a second? All right, all those in favor say aye.
Aye.
I'll oppose, same sign.
I'm opposed.
Any other questions Councilman Cowan wants?
May I understand on so I'm going to have, I don't mean to be,
Certainly.
I want to understand why you oppose the waiver of sovereign immunity language.
No, I thought we were adding we were back on the Cherokee Nation Minimum Wage
I
Act.
think we already voted on that, so it was the waiver of sovereign immunity language that Mr. Morton
Well, I
just.
don't have any problem with that. I am gonna ask for a division of the question when we vote on this, area to divide out those things, because I want you all to think about raising them $2 an hour on each one of their employees. I believe that it takes away their competitive ability. We're talking about small mom and pop operations many times, and we're going to tell them to raise their minimum wage by $2 for laborers.
Madam Speaker, can I ask Mr. Morton a question that might bear on the issue you're raising? Mr. Morton, does this language, as it's been amended, oblige a private contractor to comply with the Cherokee Nation Minimum Wage Act? This language alone?
I would have to double check, but I don't assume that it does. If this definition includes Cherokee Nation, the entities, and they have to comply with it, it just reiterates that they have to comply with it. I'm not sure if it would create the burden of someone who does not have to, because I don't have the language in front of me. So I would assume it would not, but I would like to check.
Madam Speaker, and it might make sense to table the entire subsection to do some more work on it before the next committee.
Well, I do have a concern. We're asking them to certify that they're in compliance with the Cherokee Nation minimum wage law. We're asking them to certify that on a yearly basis. I believe all of the people that will read this are going to think that means I need to pay our minimum wage to our employees. I know a lot of companies are not paying their laborers what we pay our people starting out here at Cherokee Nation. And this is the only thing that has kept them competitive and allowed them to bid on Taro jobs and to bid them at a price that they can still make money. Now we're telling them, you gotta raise your minimum wage if you want one of our jobs. $2 an hour times however many employees is gonna run into a lot of money. It's gonna take their competitive advantage away. I do think that and I'm all for everyone being paid a fair minimum wage, but we're talking about little mom and pop operations that are trying to get jobs with Cherokee Nation, and we are burdening them with so many laws that I think a lot of them are just gonna look at this and say, I'm not even gonna bid on these jobs. I can't make any money. And if I do make money, I run the risk of violating this area of the law, and I may get on a D-bar list, which means I may not be able to get business with anybody. That's a very scary thing to think that you might get on a D-bar list.
Madam Speaker, I'd entertain a motion to table this subsection, and we can talk about it more offline and work on it more.
I would make that motion.
Motion
Point of
been made and
information.
second, yes.
B1A or the entire B?
The entire
Because I
B.
have questions.
The entire
Still.
B.
Well, it's actually A, I think that
Just
we're
A?
talking about.
Okay, is that it? Okay, all right.
I
So
really don't have a problem with the rest of it.
motion to
It just
table,
concerns me.
motion to table B1A has been made and second. All those in favor say aye.
Aye.
All opposed, same sign.
Aye.
I had Councilman Lay on the list. He's been waiting for some time.
I think we've gone past where I was. Thank you, Mr. Chairman.
Plowed through it.
Yeah, you plowed through. Thank you.
All right. We'll entertain a few more questions, and then we need to wrap up in anticipation of our next meeting. Councilman Conlon.
Thank you. So on B1B at the bottom of page 7, it doesn't look like there's any rights. I can read my writing. It's like we're saying that you're guilty until proven innocent. There's no like lead time. So your competitor or competitor's relatives can come in and make an accusation, and you're immediately pulled from a job or debarred, just because there's an allegation that they violated a law, and there's a 2-year debarment. There's nothing in between. I mean, it seems to violate constitutional rights of folks, and there's no appeals process. Again, the APA kind of said stuff that this is done transparently, and with their involvement, it seems to be missing. I'm very concerned about this last part.
Would the councilwoman yield for a response?
Please. Yes.
All this says is that you certify. It doesn't say that if you're under investigation, you're debarred. It says that if, say for example, you're under investigation again by the U.S. Department of Labor because you are a recidivist violator of the minimum wage law. Tara ought to know that. But say it's an allegation that is a very small claim by an employee who says they weren't paid their minimum wage for a week of pay. I would think Tara would have the capacity to take that into consideration and say, you know, this is not we've looked into it. Now that we know about it, we've looked into it. This is not a serious concern. We're not going to debar them. But at least it puts it on Taro's radar screen that there is an investigation. It doesn't tell Taro you have to debar this company because somebody's made an allegation. It just says that if you're a company and you're under investigation, you need to tell Taro about it. And I don't understand the harm in telling Taro that we're under investigation, particularly if we believe we're in it, because you're not being barred for that reason. You're just telling Taro that you're under investigation. Does that satisfy your concerns, Councilman?
And I appreciate what you just, I mean, yes, I don't disagree with what you just shared. But the way I read this language is anyone can come make an allegation because it houses as tribal, state, or federal court. And somebody can come make an allegation and potentially just put you in any work you're doing, no matter how many tribal citizens you're employing or whatever else or what's going on, and simply stop work by making an allegation. It doesn't necessarily say that you're actually found guilty in a federal court or federal debarment list or state or other such things. It leaves a lot, the way I read the language, it leaves a lot of room for just anybody to willy-nilly come in and mess with your business, especially like a competitor or somebody else.
And I appreciate that comment. I trust that there's enough competency in our Taro office to know a minor or frivolous allegation when they see it. I also trust them to know that if there is a serious investigation of violating labor and employment law underway, that they're going to look into it. They're going to say, we're going to keep our eye on this. And if there is a prosecution, now it's on our radar screen. That's what I trust Taro to do. And if we need to add language to reinforce that, then we can.
We actually do investigations probably once, twice, 3 times a week at times. We actually receive complaints, different complaints probably every day, maybe 2 to 3 at some days. We actually go out and investigate those as well. I think, you know, the debarment is, we've actually debarred just one business for multiple violations of doing the same exact thing. They do have the right to appeal it. If you, on page 11, section 24, if the Taro staff has cause to believe the employer or contractor, they can file it with the director, then the director shall conduct an investigation. Once the investigation is over, we actually render a decision, and then that business vendor will have the opportunity to take it to the appeals, administrative appeals, and go through that legal process as well.
Madam Speaker.
Could I make a suggestion that we just add, it says whether the employer is currently subject of any investigation. Why don't we just add the word formal investigation? I would put that in the form of a motion, and if you add formal, it can't just be just anybody coming off the street making a complaint. It's got to be an actual, physical, ongoing investigation. They've got to have found enough that they're now doing a formal investigation.
Second.
Okay, all those in favor?
Aye.
All opposed, same sign.
Aye.
Okay, the ayes have it. All right. You know, at this point, we need to prepare for our next meeting. So we're making the motion to adjourn. Motion was made by Councilwoman Conwell. All those in favor say aye.
Aye.
All opposed, same sign. All right, let's give